Hey there, welcome back to the channel everyone. It's seriously a fantastic story, you know. Ever heard of those stop right there warnings in the USA? Ever been hit with a scary looking letter from a debt collector? It can feel overwhelming, but you have rights. Today, we're breaking down a powerful tool you can use, a cease and desist letter. This isn't just about telling them to stop calling. It's about demanding they prove the debt is even yours in the first place. This process is backed by a federal law called the Fair Debt Collection Practices Act, or FDCPA for short. Let's dive into what this means for you. First, your letter needs to clearly state its purpose. It's a demand for the collector to stop all collection activities until they validate the supposed debt. You'll want to include your account number for reference. Then, you state that under the FDCPA, you are formally declining to pay what you believe is an erroneous debt. If the notice they sent you was unsigned or lacked official validation, you can assert that you are canceling it due to a breach of trust or even potential fraud. A key part of the FDCPA is Section 1692E. This section prohibits debt collectors from using any false, deceptive, or misleading tactics. This includes misrepresenting the legal status of a debt. For example, if they send you a notice that looks official but doesn't cite any legal authority or jurisdiction, that could be a violation. It's essentially them trying to trick you into giving up your money or your rights. You can point this out in your letter, stating that their notice contains misleading information and is designed to pressure you unfairly. Now for the most important part, the demand for validation. Under Section 1692 grams of the FDCPA, you have the right to ask for proof. Your letter should demand that within 30 days, the collection agency provide validation and supporting evidence that you actually owe the debt. This isn't just a bill. It's proof of the original agreement, a full accounting of the amount, and evidence they have the legal right to collect it. Until they provide this validation, they have no legal right to continue collection activities. This means no more letters, no more phone calls, and crucially, no reporting this disputed debt to the credit bureaus. Your letter should make this crystal clear. State that if they fail to validate the debt within 30 days, they must cease and desist all contact. This includes calling you at home or work, mailing you, or contacting you in person. They also cannot contact your employer, your bank, or anyone else about this debt. So what happens if they ignore your letter and keep contacting you? The FDCPA has teeth. Each contact they make after receiving your cease and desist letter can be considered harassment and a violation of the Act. You can state in your letter that for every violation, you may hold them liable for actual damages, plus statutory damages of up to $1,000 for each and every incident. This includes any legal fees if you decide to hire an attorney. Furthermore, without validating the claim, they are prohibited from filing any liens or levies against you, or reporting negative information to any credit reporting agency. This protects your credit score from being damaged by an unverified claim. Finally, you can end your letter with a simple declaration. Something like, I hereby declare that the information I have provided is true and correct. This adds a formal closing to your communication. And if you enjoyed this journey into history, don't forget to hit that like button and subscribe for more deep dives into the stories that shape our world. Using a cease and desist letter this way shifts the power back to you. It forces the debt collector to follow the law and prove their claim. It's not about avoiding responsibility for legitimate debts. It's about protecting yourself from errors and aggressive or illegal collection practices. Knowledge is your best defense. I hope this breakdown empowers you to handle debt collectors with confidence. Remember to consult with a legal professional for advice on your specific situation. Thanks for watching, and don't forget to like and subscribe for more tips on managing your finances and protecting your rights. Ever felt like you're talking to a brick wall during a lawsuit? You've sent out your questions, called interrogatories, but the other side is giving you nothing but silence. It's frustrating, right? It feels like they're just hoping you'll give up. But what if I told you there's a powerful legal tool you can use to break that silence and force them to respond? This tool isn't just about asking nicely. It's about demanding answers. Today, we're diving deep into the motion to compel discovery. I'm going to break down what it is, why it's so crucial, and how you can use it to get the information you need to win your case. So if you're stuck in legal limbo waiting for answers that never seem to come, you absolutely need to watch this. Let's get started. So what exactly is a motion to compel discovery? In simple terms, it's a formal request you make to the court. You're telling the judge, "Hey, I'm playing by the rules, but the other party is not. I sent them important questions, and they're ignoring me." In a lawsuit, both sides have a right to get information from each other through a process called discovery. This includes asking written questions, known as interrogatories. These questions are designed to gather facts, identify witnesses, and understand the other side's arguments. When the other party fails to answer these questions within the time limit, usually 30 days, they're not just being difficult, they're violating the rules of civil procedure. Your motion to compel is the official way you ask the court to step in and order them to provide the answers they owe you. Filing this motion is a critical step for a few key reasons. First, it shows the court you're serious and proactive about your case. You're not just letting the other side dictate the pace. Second, and most importantly, it gets you the evidence you need. The answers to your interrogatories could contain the smoking gun that makes or breaks your case. Without them, you're fighting with one hand tied behind your back. Third, it puts pressure on the opposing party. When a judge orders them to respond, they can face serious consequences if they continue to ignore the request, like fines or even having a default judgment entered against them. This motion signals that the game of delay is over. It forces them to engage and moves your case forward, out of the frustrating standstill and toward a resolution. So how do you actually draft one of these motions? Let's walk through the basic structure. You'll start with the case caption at the top, just like any other court document. The title will be clear, Motion to Compel Discovery. Then, you'll introduce yourself as the plaintiff and state that you're moving the court to compel the defendant to answer your interrogatories. The core of your motion is the why. You need to state the facts clearly. First, you'll state the exact date you served the interrogatories on the defendant, referencing the specific rule of civil procedure that allows you to do so, which is often Rule 33. This shows you followed the proper procedure from the beginning. Next, you'll state that the deadline to respond has passed. You'll specify that more than 30 days have gone by since you served the questions, and that the defendant hasn't asked for an extension or filed any objections. This establishes that they are in violation of the rules. Finally, you get to the what you want part, known as the prayer for relief. Here, you'll ask the court for a specific order. You'll request that the judge order the defendant to answer your interrogatories within a short time frame, like 5 or 10 days. And you should also ask for a consequence if they fail to comply. A common request is to ask the court to direct the clerk to enter a default against the defendant if they miss this new deadline. This raises the stakes significantly. You'll sign it, add your contact information, and include a certificate of service, which is your sworn statement that you've sent a copy of this motion to the other party. Remember, the legal system has rules for a reason to ensure a fair process. When one side refuses to participate, it's up to you to use the tools available to hold them accountable. The motion to compel is your key to unlocking the information you're entitled to. It's a straightforward but powerful way to tell the court and the other side that you mean business. Don't let silence derail your case. I hope this breakdown helps you feel more confident in navigating this part of the legal process. If you found this information valuable, please hit that like button and subscribe for more legal tips and explainers. Thanks for watching, and I'll see you in the next video. Ever wonder what happens behind the scenes in a major lawsuit, especially one involving civil rights? It's not always courtroom drama like you see in the movies. A lot of the action happens on paper, through a process called discovery. Today, we're diving into a real-world example of this, looking at a set of legal questions, or interrogatories, from a fascinating case. Imagine a situation where a group of plaintiffs are suing a defendant, and the core of their case revolves around the conditions inside correctional facilities. To build their case, they need information, a lot of it. And they get it by serving these interrogatories on the defendant. The document we're looking at is a formal request for information, filed under the Federal Rules of Civil Procedure. It's not just a casual ask. It's a legal demand. The defendant is required to answer these questions fully, in writing, and under oath, within a specific time frame. Lying or failing to answer can have serious legal consequences. So what are the plaintiffs asking? The first interrogatory is a massive request. It asks the defendant to list, by name and address, every single penal or correctional institution in the entire state of Virginia. This isn't just limited to major state prisons. The request specifically includes prison farms, ranches, juvenile centers, halfway houses, and even local county, city, or town jails and road camps. They want a complete and exhaustive map of every place where someone can be incarcerated within the state. Just compiling this list would be a huge undertaking, involving multiple agencies and departments. This shows the plaintiffs are casting a very wide net to gather comprehensive data. But they don't stop there. The second interrogatory digs much deeper, and this is where it gets really interesting. For each and every one of the institutions identified in the first answer, the plaintiffs demand specific data about their libraries. Think about that for a moment. Why libraries? Libraries are often seen as a cornerstone of education, rehabilitation, and intellectual freedom. The state of a prison's library can say a lot about its commitment to inmate rehabilitation and access to information. The plaintiffs break down their request into three parts. First, they want to know the total number of books in each library. This gives them a baseline metric. Is it a library with 100 books or 10,000 books? The difference is massive. A larger collection might suggest a more robust program, while a tiny one could be seen as mere window dressing. Next, they ask for a breakdown of those books into three categories: fiction, non-fiction, and reference. This is a crucial distinction. A library filled only with old paperback novels is very different from one that also contains educational materials, legal resources, and reference books. This detail helps to paint a picture of the quality and purpose of the library collection. Is it purely for entertainment, or is it a tool for self-improvement and legal research? Finally, the third part of this question is incredibly specific and points towards the heart of the lawsuit. It asks for the number of books about African American culture. This isn't a random question. In the context of a civil rights case, this line of inquiry is powerful. It seeks to determine whether the library collections are culturally inclusive and representative of the inmate population. A lack of such materials could be used to argue that the institution is failing to meet the cultural and educational needs of its African American inmates, potentially creating a discriminatory environment. It suggests the plaintiffs might be building an argument around systemic neglect or cultural bias within the correctional system. By asking these detailed questions about library resources, the plaintiffs are gathering hard data to support their claims. They're moving beyond anecdotal evidence to build a fact-based argument. They can use this information to compare institutions, identify patterns of underfunding or neglect, and demonstrate disparities. For example, they could show that institutions with a higher percentage of minority inmates have significantly fewer resources or culturally relevant materials. This is the strategic, meticulous work of building a legal case. It's less about dramatic courtroom speeches and more about this patient, deliberate gathering of facts. This discovery process is what truly sets the stage for everything that follows, whether it's a settlement negotiation or a full-blown trial. It's a powerful reminder that in the fight for justice, information is power. Thanks for watching and taking this deep dive with us. If you found this look into the legal process interesting, be sure to like this video and subscribe to our channel for more content like this. Let us know in the comments what you think about the power of discovery in a lawsuit. See you next time. Hey everyone, and welcome back to the channel. Today, we're diving into a powerful legal tool that can feel a bit complex, but is super important for ensuring justice is served. We're talking about something called a petition for a writ of mandamus. And to make it really clear, we're going to walk through a real-life example of one. So what is a writ of mandamus? Imagine you're in a court case, and you need the judge to do something they're required by law to do, but for some reason, they're not doing it. A writ of mandamus is a petition you file with a higher court, essentially asking them to order the lower court judge to perform their duty. It's like saying, "Hey, higher court, can you please tell this judge to get on with it?" Let's look at this document. It starts with a notice. The person filing, let's call him John Doe, is asking the court for permission to file this petition. He wants the higher court to direct the district court judge to explain why a writ of mandamus shouldn't be issued. In simple terms, he's asking the higher court to step in and make the lower court judge act. Now, why does John Doe need to do this? The core of the issue seems to be about discovery. Discovery is the phase in a lawsuit where both sides exchange information. A key part of this is using interrogatories, which are written questions one party sends to the other, who must answer them under oath. In this case, it appears the defendant, who is a prison official, has refused to answer the questions John Doe sent him. The document points out that failing to answer these questions is a big deal. It even cites a few past cases, like Mango versus American Radiator and Shawano versus Bear Transport Company, where courts have issued serious penalties, like dismissing a case or even ordering a default judgment, just for failing to answer interrogatories. The defendant has accused John Doe of being malicious and filing the lawsuit just for harassment. But John argues that his claims are made in good faith and that he's just trying to use the proper legal procedures available to everyone. He makes a really strong point. Just because he's a prisoner and the defendant is a prison official, it doesn't mean the official is exempt from the rules. The federal rules of civil procedure apply to everyone equally. There's no special prison official exception. The document emphasizes this by citing landmark Supreme Court cases like Gilmore versus Lynch and Johnson versus Avery, which confirm that prisoners have a right to access the tools they need to pursue their legal actions. Justice isn't just for people on the outside. To highlight the double standard, John brings up another case, Denson versus United States. In that case, the government sent interrogatories to a prisoner. When the prisoner objected, the government's attorney immediately filed a motion to force him to answer, and the court agreed. The argument is clear. If a prisoner is required to follow the rules and answer questions, then the government and its officials must be held to the same standard. The law should apply equally to all parties. So what is John Doe asking the court to do? It's laid out in the wherefore clause at the end. First, he wants the court to enter an order compelling the defendant to answer the interrogatories within 5 days. It's a direct request for the court to enforce the rules. And second, he adds a consequence. He asks that if the defendant still fails to answer within those 5 days, the clerk of the court should enter a default against the defendant. A default is a major victory for the plaintiff. It's like winning the case because the other side refused to participate properly. So there you have it. This petition is a powerful example of how a citizen can hold officials and even the court system accountable. It's about ensuring the rules of the game are followed and that everyone gets a fair shot at justice, regardless of their circumstances. It's a reminder that the law is a tool for everyone. Navigating the legal world can feel like learning a new language, filled with complex terms and procedures. Today, let's demystify a few common but powerful tools used in civil lawsuits, especially for those representing themselves. First up, what happens when you've sent formal questions to the other side in a lawsuit, called interrogatories, and they just ignore them? You don't just wait forever. You file a motion to compel. This is a formal request asking the court to order the other party to answer your questions. The law, specifically rules like Federal Rule of Civil Procedure 37, gives the court power to enforce this. If the other party still refuses to cooperate after a court order, the consequences can be severe. Courts have the authority to issue a default judgment, which means the non-compliant party automatically loses the case. This isn't just a threat, it's a settled principle of law. Courts expect parties to participate in the discovery process in good faith, and failing to answer interrogatories is a serious misstep. Now let's talk about the practical challenges, especially for individuals who are incarcerated or have limited financial resources. The legal system has provisions to ensure access to justice. If you need to appeal a court's decision, but can't afford the high cost of printing legal briefs in the standard format, you can file a motion for leave to proceed on appeal on typewritten forms. This motion explains your situation, that due to poverty or imprisonment, you're unable to meet the standard printing requirements. It's a way of asking the court for permission to submit your documents in a more accessible and less expensive format. Similarly, if you're filing a lawsuit and need to serve papers or post a security bond, but you're indigent, you can file a motion to allow service by mail and dispense with the requirement for security. This motion explains that your circumstances, like being in prison, prevent you from personally serving documents. It also states that you don't have the funds to provide security, which is often required to cover potential damages if a temporary restraining order is wrongfully issued. The court has the discretion to waive these requirements to ensure that financial hardship doesn't become a barrier to seeking legal protection. Finally, what if a judge issues an order that you believe is legally incorrect? You have options. You can file a motion to reconsider. In this document, you lay out the specific legal grounds for why you think the court's order was wrong and ask the judge to change it. If you believe the issue is critical enough for a higher court to review before the case is even over, you can also ask for permission to file an interlocutory appeal. This allows an appellate court to weigh in on a specific ruling mid-case. Understanding these motions can empower you to actively participate in your own legal journey. Thanks for watching, and be sure to subscribe for more insights into the legal system. Thanks so much for watching today. I hope this got you as excited for 2026 as I am. If you enjoyed the video, make sure to hit that like button, subscribe to the channel, and ring the notification bell so you don't miss our future deep dives. Let me know in the comments if you're planning on heading to Philly for the 250th. See you in the next one.